The Copyright Act provides for fair dealing in a copyright work for the purpose of research or study, criticism or review, reporting news, judicial proceedings, or giving professional advice. Fundamentally, the court tried to argue that my speech was an incitement of violence and simply made up quotes and acted as if I said such things and implied such things because one of the clauses under the High Court's decision in the Monas case versus Queen was that for communication to be regarded as offensive in all circumstances to a reasonable person, that speech, if political in nature, must cross some boundary of being merely offensive. All right, so you're allowed to be offensive if you're an Australian politician or if you're discussing Australian politics as an Australian citizen. Although that line is crossed if that political communication or speech is not just offensive, but as well implies or incites some targeted attack which would lead to the harm, violence towards, the death of, etc., an individual or a group of individuals. This fundamentally means the High Court of Australia decided, as it has for over a century now, every time this has gone to the High Court, you are allowed to be offensive if you are discussing politics in Australia. You can upset people, you can offend people, it doesn't matter what anyone thinks or how they feel about the matter, if it is political communication, but you aren't allowed to actually incite violence. You can't say or target this group or this individual and say you want to harm them, or you want harm to come to them even, because that could incite others to go out and do that violence on behalf of those expressions. So again, fundamentally, you're allowed to be offensive. You can upset people in Australia because otherwise we wouldn't have a democracy, we wouldn't be able to have a say, and we wouldn't be free citizens if we couldn't upset each other and offend each other when it came to political matters. Because we don't all agree on politics, and that's why we have democracy, so we can all have a vote, even if we disagree and we're offended by each other's opinions. We don't have to fight it out or anything. We have civility because we can vote on the matters and have representatives put forward those policies, etc., in Parliament. So to protect our nation, to protect our Commonwealth and protect democracy, it is essential. And again, the High Court has decided this for over a century. Every single time this has gone to the High Court, it was decided that we are obviously allowed to offend, as I just explained, because otherwise we wouldn't have a democracy. We'd have a tyranny, a dictatorship. And that's not what we're about as Australians. I hope we can agree that as Australians, we want to keep our democracy. We don't want a dictatorship. We don't want tyranny. We want to be able to have a political say. So, my campaign was predominantly focused on calling out racial discrimination against a specific race of people. Racial persecution, the abuse, the harm of a specific group of people on the basis of their race. So I'm the one saying, and you can see in this transcript as we go through it, I'm clearly saying over and over again that my political position, what I'm communicating politically, and I have a constitutional right to communicate, is that there's a group of people, okay, who are being persecuted and attacked, and folk are inciting violence against this group of people. And I want that racial discrimination to stop. I'm standing up against that vilification, the persecution, the abuse, and the promotion of violence towards a group of individuals on the basis of their race. That's my entire political campaign and position, and again, you will see that clearly as we go through the transcript of what I have to say, as I speak about anti-white persecution, and I call out and speak only about anti-whites. Now, the way that this decision has, or the court has tried to decide, the judge has tried to twist this decision and take away my rights as an Australian citizen and actually be a part of that anti-white racial discrimination and persecution which I'm standing up against, thus proving me correct by persecuting me on the basis of my race because I'm a white man. And you'll see that clearly, that this judge even uses anti-white racial slurs like the N-word for black people, but those equivalent words against white people when she describes me and my behaviours and actions. So she is quite clearly and openly exposing her own bias by using anti-white racial slurs and slander against me and my character and my actions, proving me correct, again, that I have every right to have these expressions public, as they are protected political expressions, protected under the Constitution. You will notice that everywhere I mention anti-whites, like this white individual, this judge, who is persecuting and using anti-white racial slurs against myself on the basis of my race because I am a white man. Okay, so when I refer to anti-whites, I'm even referring to this specific judge who sentenced me. And she's white. Yet, then you'll see, straight away, she will twist that and then pretend, lie, slander what I'm saying and try to misconstrue this. She's, promoting misinformation and disinformation and saying that when I refer to people like herself, who proved me right about everything I say in this transcript through the case, everything I say which is supposedly offensive and targeting a specific group of people or an individual, okay, she proves me correct by living up to that, okay. She is that anti-white, yet she's white, okay? Let's pay attention here. She's the anti-white, she's white, she's what I'm talking about. She's the problem. She's what I'm against. I'm not against any race, I'm not against any, any group, any individual, but anti-whites. Who are anti-whites? Anti-whites are individuals who racially discriminate and persecute members of Western kind on the basis of their race. So vile bigots who are acting criminally and actually, partaking in criminal offences of hate crime against members on the basis of their race. Like myself, again, in this case, you'll see it. She uses anti-white racial slurs to slander and abuse myself. So she actually commits the crime of hate crime, hate speech, and racial discrimination and persecution against me in her own decision, where she's talking about how I'm calling out that very anti-white racial persecution and discrimination via anti-whites on the basis of our race because we are white. And then she twists that and tries to say that when I'm talking about anti-whites, and I clearly say anti-whites, and I only say anti-whites, folk like this white judge, okay, she twists that and says I'm talking about non-whites. So as to create that distinction allegedly have my protected constitutional political expressions cross that line, which again was determined in the 2013 Monis versus the Queen case that went to the High Court, okay, where it was decided, and it again has been the same decision. It's been exactly the same, hasn't changed for over 100 years every time it's gone to the High Court, that I'm protected and I can express what I'm saying unless I'm targeting a specific group. So she's tried to, instead of having it about her persecuting me on the basis of my race, white folk like herself who are anti-whites, okay, she's tried to twist that and make out I'm talking about non-whites so as to get away with her racial discrimination and the persecution of folk like myself and members of Western kind on the basis of our race. So the very thing I'm standing up against, she has proved that I'm correct. She's proved it's happening by trying to lie and slander, twist what I have said, and say I'm not referring to anti-whites like herself. I'm actually allegedly talking about non-whites. When I never say that, I say anti-whites when I'm referring to saying the things which she brings up and are referred to and quoted to in this case as being offensive, and thus the charge. So, again, to break this down and so we can get into this and go through the entire transcript. Fundamentally, I'm standing up against the persecution of a group and the racial discrimination of a group on the basis of their race. Those individuals who I'm standing up against, they're anti-whites, and they racially discriminate against folk for being members of Western kind, for being white. And I'm standing up against that crime, which in Australia is a crime, according to our criminal code. It's illegal. It's a federal law, and it's also a Queensland law, in Queensland state, part of the Queensland government. So it's national, and here in Queensland, it's actually part of Queensland law as well. You're not allowed to racially discriminate. It's a crime to racially discriminate. So I'm just trying to say, hey, why are all these folk getting away with this criminal offence of racial discrimination against white people? Okay? And then I'm taken to court and I'm slandered and I'm a victim of that very racial discrimination which I was standing up against. Stereotyped with racial slanders and racial stereotypes, okay? Discriminated with racial stereotypes. And that's done, again, by pretending I'm talking about non-whites whenever I mention and talk about anti-whites and the racial discrimination persecution they commit against me and my people. In order to, again, have me cross that line, allegedly, so that I can be racially discriminated against. The racial discrimination against me, the crime that's being committed against me, can be justified, okay? Essentially, I'm being dehumanized, victimized with racial discrimination to be dehumanized so that that racial discrimination against me can be justified. And this is all proven quite clearly, plain as day, in the transcript we're about to listen over.
Her Honour, this is the decision of the court following a trial. R.V. Raymond Nelson Foster. The trial took place on Wednesday the 23rd of June 21st at Ipswich. During the course of the trial, the Commonwealth were represented by Mr. Perry of counsel. The defendant, Mr. Foster, represented himself. The decision was reserved 5. I give my decision and reasons as follows. Mr. Foster is charged pursuant to Section 474.17, 1, of the Criminal Code Act Commonwealth with the offence of using a carriage service to menace, harass, or cause offence. The charge reads that between the 4th day of October 10, 2019 and the 7th day of October, 2019, at Booville in the state of Queensland, Mr. Foster used a carriage service, namely, an unknown service, in such a way that reasonable persons would regard that use as being menacing, harassing or offensive contrary to subsection 474.17(1) of the Criminal Code Commonwealth. That offence carries a maximum penalty of 3 years imprisonment. 15. With respect to the history of the matter, this matter was first mentioned on the 28th of November, 2019, and not guilty plea was indicated on the 12th of December, 2019. At the second mention, the matter was set down for a hearing to be heard on the 25th of February, 2021. On that occasion, the trial did not go ahead. It's not clear from the 20 record why that was not the case, but the matter was subsequently relisted for trial and was heard, as I indicate, on the 23rd of June 21st before me. The prosecution case is as follows. The prosecution alleged that the defendant uploaded 4 videos and alleged that in doing so the defendant engaged in conduct 25 that a reasonable person would find offensive. The videos are audio monologues. The prosecution additionally rely on evidence obtained via a search of the defendant's residence pursuant to a search warrant. That evidence includes photos, screen captures from Facebook, and videos on electronic devices, which the Crown suggest are part of the campaign on behalf of the defendant to be elected as a 30 Queensland Senator in 2019. That evidence, it is suggested by the Crown, is relevant to the defendant's state of mind in establishing the necessary mental element. In brief compass, the defence case is as follows. The defendant contends, and it does not appear to be disputed, that the material was posted as part of his political 35 campaign to run for the Senate in Queensland in 2019. He denies that a reasonable person would find the material posted in any of the 4 audio monologues to be offensive, and he urges that the only persons who would find the material offensive are unreasonable anti-white bigots who supports genocide. 40. I'm going to spend some time setting out the applicable law. Of course, the onus of proof. The Crown bears the onus of proof of both the physical and fault elements of the charged offence, to the standard of beyond reasonable doubt, pursuant to section 13.1 and 13.2 of the Commonwealth Criminal Code. By way of background, with respect to the constitutional implied freedom of political speech, the High Court in 45-249 CLR 92 made clear that the freedom to engage in political speech is not absolute or an uncontrolled license, but an implication of freedom under the law of an ordered and democratic society. It was further stated in that case, 5. The Australian Constitution does not afford a person a right of protection against unwarranted intrusions of a serious offensive kind, nor does it provide a personal right of freedom to communicate regarding matters relating to politics and government. It implies a freedom of political communication, 10, which operates to restrict the exercise of legislative power in a manner that is incompatible with or is likely to unduly restrict that freedom, but the freedom is not absolute. In line with the approach taken in Monis, it is considered that section 474.17(1) seeks 15 to protect people from the intrusion of offensive, harassing and menacing material into their personal domain. The elements the offence charged are as follows. There are 2 elements. Firstly, a person commits an offence if a. The person uses a carriage service and b. The person does so in a way whether by the method of use or the content of the communication or both that reasonable persons would regard as 20 being, in all the circumstances, menacing, harassing or offensive. With respect to the first element, the person uses a carriage service. The physical element is that of the conduct of the defendant. The fault element is not prescribed in the offence, though, according to section 5.16(1), intention is the default fault. 25 element. With respect to the second element, that being that a person does so in a way, whether by the method or use of the content, or the content of a communication or both that reasonable persons would regard as being, in all the circumstances, menacing, harassing or offensive. The physical element is that of a circumstance, that being that a reasonable person in all the circumstances would find the use or 30 content offensive, menacing or harassing.
Would a reasonable person in all circumstances, so you right now watching this, can you answer this question just to yourself? I consider you a reasonable person, average Aussie. Is it offensive, menacing and harassing to stand up as a hero against the racial discrimination and persecution of a group and defend the innocent members and the group at large from racial discrimination? because that is clearly all I have done.
It's necessary, with respect to the present case and the second element as outlined, to consider three subsections of that element. That is, firstly, what's meant by offensive, secondly, what's meant by the reasonable person, and, thirdly, what's 35 meant by in all the circumstances. I turn first to offensive. The Code provides some guidance with respect to the meaning of offensive in the form of Section 473.4. It's noted that that provision did not apply to the provision considered in Monis by the High Court. That provision states, is entitled Determining whether material is offensive. 40. The matters to be taken into account in deciding for the purposes of this part whether reasonable persons would regard particular material, or a particular use of a carriage service, as being, in all the circumstances, offensive, include the standards of morality, decency and propriety generally accepted by 45 reasonable adults, and b. the literary, artistic or educational merit, if any, of the material.
So again, as a reasonable adult, do you think it's reasonable to stand against racial discrimination? I think it's pretty reasonable. In fact, it's even the law here in Australia. Racial discrimination is a crime. Anti-whiteism is illegal.
And c. the general character of the material, including whether it is of a medical, legal or scientific character.
Which it definitely was, as you'll see later on in the transcript. My evidence provided 2 articles. One was legal documents from the UN itself, saying that I'm correct. And the other was a peer-reviewed scientific study saying I'm correct.
With respect to offensive, the term was also considered, along with the standard of offensiveness that is required in the High Court case, as I said, of Monis v. the Queen, 2013, CLR 92. Monis considered the legislative provision in 474.12 of the Commonwealth Code, being the offence of using a postal service in a way that is 5. harassing, menacing or offensive. That offence, unlike the offence before the court today, carried a maximum of 2 years imprisonment. The High Court considered the meaning of offence, and dicta from that case has been applied to the provision before the court today, 474.17, being the offence that the defendants charged with. For example, the New South Wales Court of Criminal Appeal applied Monis to 10th Section 474.17 in the case of Brown v. Commonwealth DPP, 2016, 333 FLR 20. Justice Holmes stated with reference to Monis, given the identical terms in which the respective offences are stated, the construction of Section 474.17 would be the same as for 474.12, 471.12. The court in Monis made clear that the prosecution are not required to prove that any individual in fact having been offended by the communication. That's clear from paragraph 14. Monis also made clear that the prosecution does not depend on proof that the communication was for any particular purpose, for example, 20 to cause distress or anxiety to those who received the communication. That's as set out in paragraph 15. Monis established that the standard of offensiveness is a high standard and requires more, that the communication was only likely to engender mere hurt feelings.
So as I said at the beginning of the video, the little intro, offensive in this matter has a high standard. It's not just offensive in common sense of offensive, like, oh, you were offended. Okay, doesn't matter. That's not what we're talking about here in this case in regards to the word offensive. Here it has a very high standard, okay, and it has to be more than just the normal meaning of offensive, like it might offend somebody. It has to be more than that.
Rather, the communication must be seriously or significantly offensive. Chief Justice McClelland in the New South Wales Court of Criminal Appeal, 25 decision in the case of Monis referred to the standard of offensiveness and observed, there are limits to the level of offence which may be occasioned by a protected communication. If that limit is passed, the implied constitutional freedom will not protect the maker of the statement. 30 President Alsop in the same case noted at paragraph 81 that the type of political communications protected by the law were of rational and reasoned debate, even though such debate might be full of 35 compelling, trenchant, robust, passionate, indecorous, acrimonious and even rancorous. Importantly, the New South Wales Court of Criminal Appeal in that case, Chief Justice Bathurst at paragraph 44 stated, 40. To be offensive, it is necessary that the use be calculated or likely to arouse significant anger, significant resentment, outrage, disgust, or hatred in the mind of a reasonable person in all the circumstances.
So again, let us ask ourselves this fundamental question in regards to this matter. Would you, or do you think, a reasonable person would find it not just offensive, but extremely offensive to stand against racial discrimination, which is actually a crime? So to follow the law, to be a law-abiding citizen, and not tolerate criminal behaviour like racial discrimination. Or would the only people who could possibly be offended by that be bigots who want to and who are racially discriminating, okay, who are committing that crime, and therefore they want to, in order to justify that racial discrimination and persecution, say that, oh no, you're not allowed to talk out about it, you're not allowed to complain and speak out about the abuse, the harm, the racial discrimination, the persecution of your race, your people. You're not allowed to talk about it because it's offensive. It's offensive for you to speak about the well-being of your people and to call out racial discrimination and to just ask us to stop committing crimes against you of racial hatred, racial discrimination. It's offensive to me. Okay, imagine that. What's more reasonable? That it's not offensive at all to stand against racial discrimination and it's the right moral thing to do? Or that standing against racial discrimination is such an offensive thing that it should justify the crime of racial discrimination, and individuals who are being persecuted on the basis of their race shouldn't be allowed to talk about the persecution of their own race and the racial discrimination against their race. They should be silenced. They should be charged for being offensive towards the folk who want to racially discriminate against them. I think it's quite clear that I'm innocent. I'm protected by the Constitution. And the only people who could possibly be offended by me standing against racial discrimination are those very folk committing the racial discrimination.
However, it is not sufficient if the use would only hurt or wound the feelings of the recipient. In 45, the mind of a reasonable person, he continued, such a construction strikes an appropriate balance between the implied freedom of political communication and the rights of persons to be protected from the misuse of. 5. In that case, the postal service. In the present case, of course, a carriage service. Chief Justice Bathurst continued at paragraph 64, in the present case, it seems to me that offensive communications of the nature which I have described, namely ones calculated or likely to arouse significant anger, significant resentment, outrage, disgust or hatred in the mind of a reasonable person in all the circumstances, would be communications which could provoke retaliation and thus be legitimate for Parliament to prohibit. He continued at paragraph 65. 15. Political and governmental communications would only be proscribed when they cross the boundary. Communications calculated or likely to arouse significant anger, significant resentment, outrage, disgust or hatred in the mind of a reasonable person in all the circumstances, and arouse significant anger. 20. Significant resentment, outrage, disgust or hatred in the mind of a reasonable person.
Again, what reasonable person in what universe is outraged or disgusted by good moral folk standing against the disgusting, evil bigotry of racial discrimination. I'm a hero.
It is of particular note that Chief Justice Bathurst accepted that 25 communications through the post are less likely to provoke retaliation than spoken words. I note in that context that the present case we are concerned with the spoken words, in the form of the video-audio monologues. At paragraph 67, Chief Justice Bathurst 30 continued, although the likelihood of physical retaliation is less in the case of a private communication through a postal service than in the case of words uttered in a public place, words which are calculated or would be likely to arouse 35 significant anger, significant resentment, outrage, disgust or hatred in the mind of a reasonable person have the potential to provoke physical retaliation and at the very least cause an emotional reaction in the recipient from which the recipient is entitled to protection. Such a limitation does not impose a significant fetter on political communication that would ordinarily be expected 40 to take place in an ordered democratic society. President Alsop stated at paragraph 83, the word offensive in section 471.12 should not extend to use of a character 45 calculated to cause hurt or injury to feelings or even to wound. The seriousness and gravity of the notion of offensive in this context should be limited, at least, as the Chief Justice says, to use of a character objectively calculated or likely to cause or arouse significant anger, significant resentment, disgust, outrage or hatred. Justice French in the High Court at Police Officer 59 referred to the approach adopted 5 by Chief Justice Bathurst and the President Alsop in the New South Wales Court of Criminal Appeal decision and stated, the approach of the Court of Criminal Appeal to the construction of section 471.12, in its application to offensive conduct, was orthodox. The level of 10 offensiveness defined by the court accorded with the principle of legality in its application to freedom of expression. It accorded with the need to construe a criterion of serious criminal liability relatively narrowly and clearly where the narrow construction was reasonably open. 15 Justice Hayne at paragraph 161 of the High Court judgment stated, the word offensive must be given a narrower meaning than to hurt or wound the feelings of the recipient. It is used in conjunction with menacing and harassing, and all three forms of use are treated without distinction between 20 them as meriting the same punishment of up to 2 years imprisonment. The Court of Appeal was right to conclude that the provision is to be construed as requiring a strong reaction. Justice Hayne continued at paragraph 167 that 25. The outrage caused by a communication will be worse when it arises out of or relates to matters of wider importance than relations between two individuals. The joint judgment of Justices Crennan, Kiefel and Bell at paragraphs 338 endorsed 30 Chief Justice Bathurst's examples that he'd given in his judgment. The joint judgment states as follows, the examples given by the Court of Criminal Appeal of the type of reaction which an offensive communication might engender are useful to show the level 35 of seriousness of the offense. One would expect such a communication to be likely to cause a significant emotional reaction or psychological response. The former may range from shock through to anger, hate, disgust, resentment or outrage.
Does somebody saying that we should oppose racial discrimination, nobody, no matter who they are of any race, should ever be the victim of discrimination on the basis of their race? Does me saying that make you have any of those aforementioned feelings arise? Or do you agree with me that nobody, no matter their race, should be discriminated on the basis of their race?
And the latter may include provocation, anxiety, fearfulness and insecurity. 40 It's noted that Chief Justice French at paragraph 20 stated, the criminal sanction and the application of the principle of legality both indicate a requirement for a high threshold to be surmounted before the content 45 of a communication can be characterized as offensive. It was noted by Chief Justice Bathurst, quoting from the case of Worcester v. Smith, 1951, VLR 316 at 318, where the court considered the meaning of offensive behavior under the Police Offences Act 1928 Victoria in the context of a demonstration against the Korean War, and it was quoted, the mere expression of political views, even when made in the proximity of the offices of those whose opinions or views are being attacked, does not, in my opinion, amount to offensive behavior within the meaning of this police offence.
So there you go. That's the matter settled right there. Proven innocent. Quite clearly stated that it doesn't matter if your political opponents are upset or disagree and because they think it's all right to racially discriminate on the basis of someone's race if they're white. And my political policy and position is that nobody, no matter their race, should be racially discriminated against. Racial discrimination is always wrong, even if the victim is white. So just because they disagree and they think it's all right to racially discriminate, that's their political position, that's their ideology, that it's okay to racially discriminate as long as the victim's white, because they're anti-whites, that's not good enough. That doesn't count as it being offensive. That's just them disagreeing because they're racially discriminating bigots, they're anti-whites who hate us on the basis of our race.
10. In the case of Ball v. McIntyre 1966, FLR 237, a student was charged with behaving in an offensive manner in a public place, contrary to the Police Offences Ordinance 1930 Victoria during a political demonstration against the Vietnam War. Quoting Justice Kerr's remarks, Chief Justice Bathurst quoted as follows: 15, 20, 25, 30, 35, 40, 45. The question therefore is, was this political behaviour, because of its nature and circumstances, also offensive behaviour? It is clear that some kinds of political behaviour can be offensive behaviour in the eyes of the law, but one must be careful in the case of political behaviour not to condemn as offensive conduct of which one disapproves on political grounds. Justice McClelland indicated at paragraph 110 that the assessment of the standard of offensiveness of the particular communication can only be undertaken by attempting to identify particular characteristics of the conduct or its possible consequences. Justice McClelland noted at 116, communications intended to incite a physical response occasioning harm to an individual or group may be universally condemned in any generation, but those which offend or hurt feelings or occasion moral outrage may not have the same quality. It's noted this appears to be a more restrictive test than that required by Chief Justice Bathurst and other members of the court, but it does demonstrate an example of conduct that would be held to be offensive and outside the protection of political free speech. I turn into the second matter for consideration, the reasonable person. The reasonable person test is an objective test. With respect to the characteristics of the reasonable person, Chief Justice French and the High Court in Monash at paragraph 44 stated, the requirement that the prohibited use of a postal or similar service be one that reasonable persons would regard as being, in all the circumstances, offensive, imports an objective but qualitative criterion of criminal liability. The characteristics of the reasonable person, judicially constructed for the purpose of such statutory criteria, have been variously described. Capital 8. Reasonable man in Ball v. McIntyre was reasonably tolerant and understanding.
If an Aboriginal stands up and says they want racial discrimination against Aboriginal people to stop, and a person who hates Aboriginals responds to that and tries to silence that Aboriginal by having them charged for offensive speech, is that person who hates Aboriginals a reasonably tolerant and understanding individual? If a Jew stands up and complains and demands an end to anti-Semitism, and then an anti-Semite responds to that Jew and tries to silence that Jew from defending themselves by having them charged for hate speech or for being offensive, is that anti-Semite a reasonably tolerant and understanding person? I hope we can all agree, no. People who hate Aboriginals and anti-Semites, and then as well equally anti-whites, are not reasonably tolerant or reasonably understanding people. They're disgusting bigots. So everyone who's trying to say I'm offensive are disgusting bigots. No different from an anti-Semite or someone who hates Aboriginals. And the only person who would even think that that's not the case is somebody who thinks that the races aren't equal, and for some reason, because I'm white, I don't count, I don't matter. It's not the same. If you're an anti-white, it's not the same as being an anti-Semite. Somehow it's worse if you're an anti-Semite. Somehow it's worse if you hate Aboriginal. No. It's just as bad if you hate Aboriginal, just as bad as if you're an anti-Semite. It's just as bad if you hate Asian people, and it's just as bad if you're anti-white. So none of those individuals surely can be counted as reasonably tolerant or reasonably understanding people. And again, the only folk who are opposing me are anti-whites. On the same level as anti-Semites. Disgusting, racially discriminating bigots, vile monsters. Alright? Scum of the earth. So, an anti-Semite says to a Jew, you're not allowed to talk about anti-Semitism, and has them charged for offensive speech. Is that anti-Semite a reasonably tolerant and reasonably understanding individual?
And reasonably contemporary in his reactions, a reasonable person was said, in the Supreme Court of New South Wales, to be neither a social anarchist nor a social cynic. The reasonable person is a constructed proxy for the judge or jury, like the hypothetical reasonable person who is consulted on questions of apparent bias. The construct is intended to remind the judge or the jury of the need to view the circumstances of alleged offensive conduct through objective eyes and to put to one side subjective reactions which may be related to specific individual attitudes or sensitivity.
Well, isn't it quite clear for everybody? This judge was unable to put aside her bias because she's anti-white. So she thinks it's all right to racially discriminate against me on the basis of my race. Okay? Or do you think she would also try to slander and talk down, throw racial slurs at a Jew who simply spoke out against the persecution of Jews and said that anti-Semitism has to stop? Do you think this judge would treat a Jew saying that anti-Semitism needs to stop the same as she's treating me, a white man, who's just saying anti-whiteism needs to stop? Or do you think she might be an anti-white and her racial prejudice might be showing a little bit?
10. Chief Justice Bathurst referred to Justice Reynolds' statements in an unreported Court of Criminal Appeal case in New South Wales on the 4th of May, 1973, that involved an anti-apartheid demonstration, pointing out that 15. The reasonable man provides a flexible measuring stick, one which can take account of social and technical progress and, at the same time, one which can be applied with due regard to human frailty. Chief Justice Bathurst continued to quote Justice Reynolds as follows: 20, 25, 30, 35, 40, 45. It is submitted that the type whose reaction to words or conduct should give them their objectively insulting or offensive character be the sane or balanced citizen, one lacking the vanity of the coroner and ex parte collier or the touchiness in money matters of the prosecutor in cellars or the exaggerated sense of personal rectitude of the prosecutor in winded. Chief Justice Bathurst indicated. One might add to that characterization of persons, a person not overly sensitive to robust political debate. Chief Justice McClelland at paragraphs 99 to 107 spoke and discussed the reasonable person. In the present context, the reasonable person will be attributed with knowledge of the Australian system of government and with the nature of political discourse within the Commonwealth and otherwise with the knowledge of acceptable contemporary norms of, in that case, written communication between persons. The reasonable person will be mindful of the robust nature of political debate in this country when considering whether in the circumstances of the particular case the use of the postal service was menacing, harassing or offensive. He contended, if the level of invective in any postal communication was such as to cause psychological injury to an otherwise reasonably robust personality or tend to invite a spontaneous response in breach of the peace, reasonable persons may also regard that use as relatively, 10, 15, relevantly offensive. This conclusion will follow from the fact that the reasonable person would consider that the offense occasioned by these uses of the service has the consequence that they fall outside the limits of legitimate political debate. I turn then to the third element of the second element of the offense being in all the circumstances and the meaning to attach to that. Chief Justice Bathurst considered that the primary judge's view that the words in all the circumstances, these qualifying words, he stated 20, would in my view allow the tribunal of fact to determine the context in which the postal service in the case 25, 30, 35, 40, 45, was used by an accused person, including the intended identity of the recipient of a postal communication, any circumstances surrounding that person and his or her receipt of such an article, the circumstances of the accused including it seems to me his state of mind and the extent to which that might be genuinely reflected in the content of the communication, contemporary debate about current political issues, contemporary values about political debate in a robust democracy and similar matters concerning the circumstances in which such a communication is made. With respect to context, President Alsop noted at paragraph 88 that the tribunal of fact would, of course, be required to recognize that one of the circumstances that reasonable persons would take into account would be the recognition of the existence and importance of the freedom of political expression. Further, with respect to context, Chief Justice Bathurst noted at paragraph 56 that it has been recognized that in this country political debate can take place in a fashion that is generally robust, frequently insulting and sometimes acrimonious. Justice Kirby made a similar observation in the case of Coleman v. Power, which is quoted at paragraph 104 of the Supreme Court New South Wales judgment in Monash about the robustness of political debate in Australia, stating that 5. Insult, emotional and invective are part of the armory of political persuasion and the struggle for ideas. Justice Kirby stated as follows, 10. One might wish for more rationality, less superficiality, diminished invective and increased logical and persuasion in political discourse, but those of that view must find another homeland. From its earliest history, Australian politics has regularly included insult and emotion, calumny and invective, in its armory of persuasion. They are part and parcel of the struggle of ideas. 15. Anyone in doubt should listen for an hour or two to the broadcasts that bring debates of the federal parliament to the living rooms of the nation. This is the way present and potential elected representatives have long campaigned in Australia for the votes of constituents and the support of their policies. It is unlikely to change. By protecting from legislative burdens governmental and 20 political communications in Australia, the Constitution addressed the nation's representative government as it is practiced. It does not protect only the whispered civilities of intellectual discourse. I turn, then, with respect to the law to the fault element of the second element of 25 section 474.17 being recklessness. The fault element is not prescribed in the physical element, that is a circumstance. So according to section 5.16(2) of the Criminal Code, recklessness is the fault element. Recklessness is defined in section 5.4 as follows. A person is reckless with respect to a circumstance if he or she is aware of 30 a substantial risk that the circumstances exist and will exist and b. having regard to the circumstances known to him or her, it is unjustifiable to take the risk. It set out in subsection 3 that the question whether taking a risk is unjustifiable is 35(1) of fact, and in subsection 4, if recklessness is a fault element for a physical element of an offense, proof of intention, knowledge of recklessness will satisfy the fault element. I turn, then, to the evidence. The prosecution in this case relied on, firstly, the admission. At the outset of the trial, the defendant made admissions in the form of a written document attaching a DVD that was tendered as Exhibit 1. That 40 admission reads as follows. The defendant admits, 1. At all times the defendant was a user and operator of the following accounts created by the defendant. A Facebook account Raymond Foster. B. Facebook account Raymond Foster Senate candidate for 45 Queensland. C. Facebook account Foster 2022 Legion. D. YouTube account Raymond Foster Senate candidate for Queensland. 2. The defendant intentionally uploaded, posted 4 videos, copies of which are contained straight, the CD annexed to these admissions, to his Raymond Foster Senate candidate for Queensland YouTube account described as follows. The admission sets out the 4 videos entitled, This is War, dated the 6th of October 5, 2019, Our Greatest Adversary, dated the 8th of October, 2019, or, rather, uploaded, Those dates: the third video entitled Nowhere to Run uploaded on the 13th of October, 2019, and the fourth video Dear Commonwealth uploaded on the 16th of October, 2019. The third paragraph of the admission reads, 10. By engaging in the conduct described in the preceding paragraph, the defendant intentionally used a carriage service within the meaning of the term in Section 7 of the Telecommunications Act 1997 Commonwealth. As I said, the CD-ROM attached, contained in that exhibit, contains the recording 15. The four recordings referred to in the admission at paragraph 2 the subject of the offence allegations. The prosecution also relied on evidence of Detective Senior Constable Ian Bunnett. Detective Senior Constable Bunnett gave evidence in person. He's an investigator in the Counter-Terrorism Investigation Group. He indicated that he knew the defendant as a consequence of his involvement in an 20 unrelated matter. I indicate at this point that I have placed no weight whatsoever on that comment. He was then the team leader on the 18th of October, 2019, when he was tasked to investigate matters related to the information received by the National Security 25 hotline concerning an anonymous complaint. Because the information received from the informant was minimal, Detective Senior Constable Bunnett explained that he undertook an investigation on the internet using open source to access websites. That is, he reviewed public forums on the internet. He reviewed two public platforms, being Facebook and YouTube. 30. He reviewed the sites referred to in the admission at paragraph 1, being 3 Facebook accounts and 1 YouTube account. He did not require any specific police methodology in order to access those sites. He observed content of the Facebook accounts and quickly, in his view and evidence, observed the sites were linked. Given 35. The author was the same. The sites contained similar photos, material and pictures and posted content. He described the content of those sites as racially based and divisive in language, content and theme. He used programs available to both the QPS and members of the public to take 40 screen captures. They are the subject of Exhibit 2 in these proceedings. He observed content on the YouTube account referred to in admission paragraph 2, and he viewed the 4 videos referred to therein. He indicated he applied for a search warrant and executed a search warrant on the 23rd of October, 2019, at the defendant's address. It was indicated by this witness that the second witness to be called by the 45 Crown was also present at that during the course of the search. He gave evidence that several items were located and he took photos of those items. The photographs appear in Exhibit 3, including posters, a mobile phone, a computer, a letter dated the 13th of October, 2019, and a flag. He also located a laptop computer, Nokia mobile phone and a USB. 5. Detective Senior Constable Bunnett is an experienced officer. He gave his evidence in a coherent, professional manner. He's considered to be a reliable and credible witness and his evidence is accepted. The Crown also relied on Mr. Kevin Mount, who is a computer investigative analyst 10 employed by the QPS since 2014, having been engaged previously in a similar role in the UK since 2008. He is extensively trained in software and computer forensics. He attended the execution of the search warrant on the 23rd of October, 2019. His role, he indicated, was to assist officers and to look for digital evidence. He prepared a forensic examination report for the QPS dated the 8th of February, 2021. 15 extracts of that report were exhibited in these proceedings. Exhibit 4. He located a video file on the defendant's laptop device entitled Am I Racist? That's Exhibit 5 in these proceedings and indicated that that video was created on the 10th of February, 2019. He gave evidence of a further video located on the 20 defendant's desktop PC created on the 16th of October, 2019. I note that's the date of the fourth video. The subject of the admissions entitled, the video found on the defendant's desktop during the course of the search was entitled Election Interference, and that's Exhibit 6 in these proceedings. 25. That was the evidence for the Crown. The evidence of the defendant was as follows. He chose to give evidence but not to call evidence. He tendered 2 academic articles. He exhibited Exhibit 7 and Exhibit 8 in these proceedings. He spoke and gave evidence of his views, including that he was charged as a consequence of his political campaign. He indicated he was arrested and raided because of his white skin. He 30 gave evidence that everybody deserves a homeland and this includes me and my people. He gave evidence that he wanted to protect my family. I don't have white guilt. He stated, "I got arrested for saying that what was happening to my people was genocide." 35. He spoke of white folks suffering psychological trauma. Under cross-examination he confirmed his political campaign began in September of 2019 and may have been commenced earlier than that point. He rejected the suggestion that he had been referred to in the what's referred to as Billabong Chinwag videos. That's the 4 videos the subject of the admission to non-white immigrants as vultures and enemies. 40. Stating, "No, that's a lie. It's disgusting to suggest I would say that and it's white slander."
I obviously didn't even say that. Okay. I said it's anti-white slander. No one, why would anyone say it's white slander? It's anti-white slander against me. It's racial discrimination against me. Again, as I was saying, evidence that this judge can't put her bias aside, her racial prejudice, her hatred for innocent members of Western kind. And as I mentioned again in the intro to this video, here we will get into where and how blatantly and openly this anti-white judge will take statements of me talking about white folk like her, and then she'll make out as if I'm talking about non-whites. I don't know how talking about white people like her, who are anti-whites, could possibly be me talking about non-whites, unless anti-whites like her, who hate people like me on the basis of my race, simply want to try to justify their own hatred and racial persecution, prejudice, discrimination against folk like myself, because she hates folk like me on the basis of my race.
During the course of his evidence, the 4 videos referred to in the admission exhibit 1 were played. With respect to the first video entitled "This Is War," uploaded on the 6th of October, 2019, the defendant was cross-examined. He agreed he had claimed white people were in a war but sought to qualify this by way of his oral evidence, suggesting the war as being of a spiritual and cultural kind. He demonstrated, appreciating at the time that there would be a large number of people who would not agree with his statements, indicating that whilst there may be some confusion from a lack of understanding, that they would not disagree.
And am I wrong, folks? Do you disagree with me? Do you think racial discrimination is okay, like this judge? Or do you agree with me that racial discrimination is always wrong, no matter the race of the victim? You can't justify it, because that's just further racial discrimination. You agree with me, eh? Yeah, thought so. And you disagree with the judge, because you're actually a reasonable person, unlike the judge who's a bigot.
He indicated, when he was referred to being invaded by enemies and foreigners, that he was referring to 5 non-Australian citizens occupying by non-military force. With respect to his statement in that video, "We have enemies in our nation who are plotting to massacre us and rape your children," the defendant accepted that those individuals would find that offensive, but not a reasonable individual who would. 10.
And again, do you agree or disagree with me, folks? Do you find it offensive if I step up and warn you and let you know and protect your children by letting you know there's folk out there who want to harm your children because they're anti-whites and your children are white? So they want to racially discriminate against you and your children and abuse your children. Is that offensive to you, that I'm helping protect your children? Or do you think the only people who would be offended by that are those anti-white bigots who want to abuse and harm your children? Again, obviously, you agree with me. And you're starting to see how psychotic this judge is. That she's trying to justify the harm and abuse of your children and saying that I'm bad because I'm stepping up to protect your children?
As part of the campaign, in which the defendant used similar language to that in the videos, The defendant agreed that occasionally people responded to him by calling him a racist and threatening to assault.
And that they are anti-white, vile, racially discriminating bigots who call us things like the R word, okay, which means evil, bad, white, who wants to hurt and harm non-whites, scary, bad white man, racially stereotyping us as some bad whitey who wants to hurt non-white people. And she has to even lie and say that when I'm talking about white anti-whites like herself, that really I'm not actually talking about white anti-whites like her, like I have been openly and quite clearly. Really, I'm secretly actually talking about non-white people because I'm the R word and I'm a big, bad, scary white man who wants to hurt all the non-white people, because she's decided to racially stereotype me as the R word, like anti-whites do.
He stated in his evidence, "Yes, I almost died from an assault, multiple assaults." 15. He recalled 2 occasions, one when he was attacked by a person he described as a junkie, another when the defendant was putting up posters and he described being stalked by a person who was physically up in his face and tried
into oncoming traffic, and I almost got hit by a fucking car and died. But let's just leave that bit out. I just got pushed. What?
The defendant said he was at the time promoting white well-being and they did not agree with the well-being of white people in general. "I'm used to that," he denied. 20. Signing off the video with the words "Hail Victory." He denied that signing off the video with the words "Hail Victory" would evoke an association with Nazi Germany and Heil Hitler, pointing, rather, to his Christian values and the meaning to be attached to Hail Victory being God's will, God's.
And if anybody has a problem with me saying hail or hail victory, you're anti-white scum. I'm sorry, but you're anti-white. Hail. Do you know what hail means? It means the same thing as namaste. It means the divine essence in me, okay? I put aside my human tendencies, I put aside my human ignorance, and the divine part within me. I allow God's love to come through me, connect with the part within you, which is a spark of the divine, and I honor the divinity within you. I honor the divinity within your soul, no matter who you are. That's what it means when you say hail. Although it obviously makes sense that an anti-white who's trying to slander me and stereotype me, racially discriminate me with the stereotype of the baddie in the anti-white narrative, a big bad white man, alright, would obviously use something like me saying hail victory to try to slander me and stereotype me with that racial discrimination.
25. He denied appreciating the risk that when he referred to non-white immigration amounting to white genocide, that reasonable persons would regard that statement as associating a policy of immigration with murdering people of a particular race, stating that the definition of genocide to his mind means erasure of a race. Not
only is this common sense in Australia, in fact, we're all educated on this fact in primary school. I'm not sure if this judge has just never heard of stolen generation or not, but find me anybody, any reasonable, person who actually thinks that if you breed Aboriginals out of existence with stolen generations, keep taking their children and breeding them out of existence until they no longer exist, that's not a genocide because you didn't actually kill them. What? Are you insane? Pretty sure most Australians agree that if we've wiped out the Aboriginals, until there was literally none left, then there'd be none left. Even if it was only through stolen generations and breeding within a different population. You don't have to kill anybody to genocide an entire race. No deaths at all. Nobody has to be killed. You can just have babies. You can build a town in their hunting grounds. You don't have to kill them to genocide them. We all know this as Australians. Not only this, the evidence which was provided to the judge, which was UN documents, international law, which spoke directly about this and actually pointed this out. That yes, genocide, and specifically the legal definition under international law, isn't just killing people. That's ridiculous. But for some reason, this anti-white psycho judge has fantasies about killing people and is obsessed with murder and killing, and then projects that onto folk like me. But sorry, love, that's your own head. That's your own messed up thoughts. You're the one focused and, obsessed with killing, murder. Okay? Everyone else in the world, we all know, that you don't have to kill people to genocide them. Why are you so obsessed with murder and killing? This anti-white judge has problems.
He indicated that, indeed, the majority of people would agree with 30 his views, stating that it would only be the loud minority of anti-whites that don't. He indicated in his view the average reasonable people.
And you all do agree with me, don't you? That racial discrimination is wrong. All people, no matter their race, no matter their immutable characteristics, deserve to be treated with well-being. They deserve to have well-being and to be able to uphold their culture and their traditions and to pass on their traditions and culture and to thrive in that culture and their traditions with their people. They should be allowed to love their people, to love themselves and enjoy life.
With respect to the second video recording entitled Our Greatest Adversary, which was uploaded on the 8th of October, 2019, the defendant was cross-examined with 35 respect to that. The defendant denied being aware of any risk. The content of that video was offensive, stating, "I don't think a reasonable person would find it offensive, unless they find democracy to be offensive." The defendant characterized his comments in relation to politicians, bankers, judicial system of courts and police officers serving anti-white, anti-Australian ends, as, "It's just an immigration 40 policy, and that's..."
And am I wrong? What would a policy on immigration be other than a political policy?
With regard to his statement that the nation of Australia belongs to us white Australians, that being our birthright, and it is being stolen from us, the defendant suggested that it was not offensive to us.
And why would it be offensive to Aboriginals to say that our country, as in ours and theirs, ours, okay, us, we're together, us whites and Aboriginals are in this together, we're both being erased, okay? It's not just a genocide, it's not just white genocide, it's Aboriginal genocide as well. In fact, the Aboriginals will be erased first, before whites, because they're a smaller population. So, speaking about how the Aboriginals' continent is being stolen from them, and that they're being erased, why would that offend them? Aboriginals appreciate when you fight for their well-being. As a fellow Australian, you actually treat them as human beings. I don't know what this judge thinks about Aboriginals, but I see Aboriginals as human beings in this fight with me, a white Australian, to fight for our country, our white and Aboriginal country. The white nation, Australia, and the Aboriginal continent, the land. Together, that's white and Aboriginal. But if we keep letting everyone else come in the country, there's going to be no more Aboriginals, and no more white people left. All Australians will be ethnically cleansed, erased, through mass immigration. That's why my policy was to help stop the genocide of Aboriginals and white Australians by just stopping immigration. But apparently that's scary, bad, evil, and that means I want to hurt non-whites. Evil white man. What? This is crazy stuff, folks.
Stating that the vast majority of 45 his Aboriginal friends agree that Australia is a white country built by white people. When asked if he agreed, his reference to the elitist class of parasites transferring our wealth from our pockets to their own was inflammatory, he responded straight. Objective descriptor to live off a host. They are literally parasites. I'm not insulting them. They are parasites by definition. With respect to the third recording entitled Nowhere to Run, uploaded on the 13th of the 5th of October, 2019, under cross-examination, the defendant denied his words. The law is, kill or be killed, is provocative, stating, not at all, it's the law of nature. The defendant stated under cross-examination, I'm for the equality of all people. I love all races. I don't agree with anyone who racially discriminates. I just don't like it.
Because, I don't know, for some reason, I personally really hate racial discrimination. I don't know, it doesn't sit well with me. It doesn't sit right with me. I don't know, maybe I'm weird. Maybe there's something wrong with me. But yeah, this judge, she thinks racial discrimination is okay and justified, and it's the good, right thing to do. We're supposed to discriminate on the basis of people's races. This is what this judge thinks. So maybe that's why she thinks there's something wrong or bad about me, because I hate racial discrimination. But all reasonable people, you yourself watching this video, you agree with me. Almost everyone in the country agrees with me. Okay, racial discrimination is bad. It's wrong. It's evil.
He denied his reference to, they will hunt us down, would cause 10 offensive, stating, no, any reasonable person would want to stop the persecution.
Again, what do you think, viewer? You're a reasonable person. If there's a Jew and he's panicking, he's being persecuted, he's scared, and he's like, help me please, there's these anti-Semites and they're trying to abuse and hurt me because I'm a Jew. Do you have a problem with that Jew now? Is that Jew bad because he doesn't want to be victimized? Because that's what this judge is trying to say.
Stating further, a reasonable person is not an anti-white bigot. He denied the video was offensive, stating, only an anti-white bigot would be offended. So unless you're for genocide, it's not offensive and any reasonable person would agree. 15. He was asked about the fourth video entitled Ye Commonwealth, uploaded on the 16th of October, 2019. Under cross-examination, the defendant denied being aware of the substantial risk that a reasonable person would find the content of the video to be offensive, answering that only anti-white bigots would find.
Well, when the video is literally only saying one thing, it literally only says that anti-whites, okay, who commit treason, so anti-white criminals committing treason, should be put on trial. And they should be charged for their crimes. Okay, that's literally. I'll give you a copy of the video if you want it, and you can listen to it yourself. I can give you, I'll print you the actual letter. It was a letter, I wrote a letter, and then I read the letter out. And literally, it's literally the whole letter. Everything in it is literally just saying that anti-whites who are committing treason, criminals, should be tried for that treason, for the crimes that they are committing. And that, oh, this isn't in the video, but I'll add this now. Obviously, the only people who are going to be offended by that are those anti-whites who are committing treason, those very criminals. Who could be offended? The video is just saying, like, again, you're a reasonable person. What do you think? If somebody or something is saying, these criminals committing these crimes should be arrested and charged, put on trial and prosecuted for the crimes that they're committing. Do you agree? Or do you disagree? Oh, that's right. Unless you're a criminal, you agree with me, don't you? That criminals should be charged for their crimes. Actual criminals go out there actually hurting people, exploiting people, harming people, committing treason, fraud, etc., robbing people, thieves. Or do you think that, like, if a thief comes and, you know, breaks into your mother's home and steals her jewelry, oh, well, he shouldn't be arrested. Good on him. Your mum's white anyway. Like, what? No, I'm pretty sure you agree with me, don't you? Yeah, you do. That if some thief breaks in to your mum's home and steals your mum's jewelry and then frickin' beats her up because she tries to, you know, fight him off or something, and your mum gets frickin' bashed by some frickin' home invader, I'm pretty sure, I hope, you want that home invader put in jail for his crimes. Because I do. But not this judge. Apparently. She thinks, nah, criminals, nah, what are you talking about? That's offensive, Raymond. How dare you say criminals should be put in jail or put on trial and be prosecuted for their crimes?
He gave 20 evidence of having been banned from Facebook on multiple occasions. I turn into my analysis of the evidence. Generally speaking, the defendant expresses views regarding supporters of non-white immigration or people who do not oppose non-white immigration as being complicit.
And here we go. Let's all listen to how this judge loves to spin disinformation, lies, slander, make stuff up. No, it's not me suggesting this, Your Honour. You read the documents, the law, the international law, which supersedes your court, okay? I thought as a judge you'd understand law and legal documents, but it wasn't me saying that, Your Honour. It was the UN. The UN wrote that into international law. It's not my opinion.
Being guilty of the 25 offence of treasons and suggests that those complicit in white genocide ought to face the death penalty. Chief Justice French at paragraph 67 of the High Court decision in Monis referred to lunar elements of political discourse. 30 he stated at paragraph 67, the reaction elicited by an offensive communication may depend upon its source. If emanating from a marginal voice on the fringes of political 35 discussion, it may not be taken seriously enough to induce an emotional reaction in any reason.
So, kind of like my tiny, independent, unfunded, almost unknown, without any support, just running it myself, political campaign. Oh, okay. So another reason why I'm innocent. Cheers.
There are many communications, of which the internet provides more than ample evidence, from what might be described as lunar elements of political discourse. Such communications may not be taken seriously enough by reasonable persons to upset anybody. 40 I have considered whether the communications contained in the 4 videos fall properly to be considered as communications from the lunar elements of political discourse as described by Chief Justice.
Yeah, like my campaign. Did you even know I was running in politics? Did you know I was a politician running for the Senate? Oh yeah, you've seen me all over the TV and everything, eh? Totally legitimate, mainstream politician, taken 100% seriously by everyone. For sure. I'm sure, but yet this judge is going to try and make that out somehow, obviously, because as we've seen so far with everything this judge has done, he's tried to lie, slander me, racially discriminate against me because I'm a member of Western kind and she's a vile, sick, bigoted, maybe psychopathic, obsessed with murder and killing, racially discriminating anti-white.
Whilst it has some appeal in the present circumstances, I am not persuaded that, taken as a whole, or 45 each video individually, that the content of the communications fall within that category. This is so particularly given at the time the communications were made. The defendant was running as a Senate candidate for Queensland, and the magistrate was posted as part of that specific political campaign, thus providing an air of legitimacy to the source of the communications that may not otherwise have been the case. 5. I turn then to the first element of the offence, that being that the defendant intentionally used a carriage service. The defendant accepts he intentionally used a carriage service when he intentionally uploaded the 4 videos contained in Exhibit 1. That element is proven by way of the admission. The written admission, Exhibit 1, provides proof of both the physical and fault elements of the first element of the 10 charge, being that the defendant intentionally used a carriage service. In those circumstances I find the first element is proven beyond reasonable doubt. I turn then to the second element, that being that the defendant used the carriage service in a way, whether by method or use or content of a communication or both. 15. That reasonable persons would regard as being, in all the circumstances, menacing, harassing or offensive, and the defendant was reckless as to that circumstance. This is the only contested issue for consideration and determination. As previously indicated, the Crown bears the onus of proving both the physical and fault elements to the requisite standard. With respect to the first aspect of that second element, it's 20 necessary to consider the content that was posted, to consider whether the defendant used the carriage service in a way that reasonable persons would regard as being, in all the circumstances, menacing, harassing or offensive. I turn to consider the content of the video entitled "This is War." In that video, the 25 defendant seeks to alert his audience to the most serious matter in their entire life, the literal war taking place. It's a rallying call to retake our nation and try the traitors to halt. Defendant states in that video, "We have enemies in our nation who are plotting to massacre us and rape your children. This is no joke. This is no conspiracy. There is a white genocide happening globally. We, 30, are in a war for our survival, for the survival of our people." He refers to having to identify those willing to fight on his side and those who are traitors, and to finding out which is which before shit hits the fan.
And I still suggest you do. Okay? For your own safety, for the safety of your family, for the safety of your children. Okay? All your mates, whether they're white, non-white, doesn't matter. Okay? Race is irrelevant. The only thing that matters, are they anti-white? Do they think it's alright to racially discriminate against somebody on the basis of their race? Or are they for white well-being and the well-being of all people, regardless of their race? Do they believe all people deserve to be treated with humanity and decency and not be victims of racial discrimination? Because I don't know about you, but I don't trust people who think it's alright to racially discriminate against folk, alright? Especially, and because I'm white, and majority of people in Australia are white, and the most common bigots who are out there racially discriminating against people in this nation are, you guessed it, anti-whites. So if you want to help protect your children, if you want to help protect the average Australian child from vile bigots who want to harm them on the basis of their race, then I suggest I promote you go out, you arm yourself, you arm yourself with a psychological defense to the psychological warfare being waged upon you and your people and your family and your children. Have you seen the curriculums in the schools? Have you seen what they're bombarding your children with in school? The shit that they're teaching them now? These anti-white monsters trying to promote pedophilia on your kids and stuff. So, yeah, I'm not going to change my tune. I still think you should arm yourself with the psychological defense, okay, which is going free of the anti-white narrative. Learning how to love and forgive and help others to love themselves, okay, so we can put an end to this racial discrimination before it gets too bad. Because you'll hear, okay, as was explained by the High Court, is protected constitutional expression as it's emotive. It's supposed to get you feeling. It's supposed to make you think, all right? And it's not targeting any specific groups or individuals, so it doesn't cross that line, so it's all good. It's protected constitutional speech. And you'll hear what would happen, okay? What definitely would happen, you can see it in places like South Africa. Okay? It's happening. You'll hear what I say, what would happen if we don't make a serious change, if people like me can't get into Parliament and put an end to this normalisation of racial discrimination and bigotry before it's too late, before something like what happened to the Jews happens, and what's happened to the whites in South Africa happens to us here in Australia. All you got to do is Google, just ask any Jew, look up what happened to the Jews 100 years ago. If you're unaware what happened to the Jews 100 years ago, okay, pretty bad. And if you're unaware what's happened in South Africa over the past couple of decades, the same thing that happened to the Jews 100 years ago, which is the same thing being promoted for us Aboriginals and white Australians in Australia now. Okay? And if you don't want to put an end to that, if you think it's all right, you want to see innocent children being murdered, you want to see people having their front gates kicked in and whole gangs of people run in to rape and kill their children in front of them and boil their babies alive in bathtubs and skin them alive in front of them and then torture their wives and then kill their husband last. So making him watch it all because of their race, hunting them down because they're white. And you can see it yourself, okay, if you don't believe it, if you don't know what's happening in South Africa right now, a country that used to be a white nation, okay, and it started off as a white nation, and then the Africans moved in as immigrants. And then look at South Africa now. And then you tell me that's what you want for Australia, that's what you want for Australian citizens, and that's what you want for the innocent children, innocent Aboriginal children and white children in Australia. Is that the chaos you want? And then tell me I'm wrong to use emotive language to try to prevent that from happening.
Because war is no place when war actually breaks out, like actual civil war, when there's actually people in the streets killing each other with machetes and stuff, which is coming. It's definitely 35 coming, all right. The defendant refers to a person who rips down his posters in his campaign being told by him that he'll be tried for treason for being complicit in white genocide. The defendant states in that video, if you're not with us, you're against us, and you're 40 guilty of genocide.
Again, the judge conveniently forgets the legal document she read herself, which is an article in the court case. No, I didn't say that. That's what UN said. That's what international law says. But she's trying to make out like it's just me saying that. It's not actually the law. They're not actually criminals who should be charged for the crimes they're committing. That's offensive. Remember? That's offensive. Criminals being charged for their crimes? How dare you, Raymond? You're a racist.
Those who are not with us will perish when we rise up. The defendant suggests that, while the law needs to be followed presently, in the event of being invaded by enemies, by foreigners, if a civil war breaks out, true blue Aussies need no more follow the law and desist from violence.
This is just plain lies here. I definitely said we need to follow the law. We can't break the law. And I don't know what this judge is trying to imply here. What, if we're being invaded by foreigners? Like actual army coming in. Like imagine an army lands here. They're shooting people in your street. We're actually being invaded. There's a war happening. We're being invaded, hypothetically. And this judge is trying to say, oh, no, don't fight them back. Don't fight back. It's violent if you try to defend yourself from... Like, so if, right now, if Ukrainian citizens defend themselves against Russians, oh no, that's evil violence, you can't do that. Or are they just citizens fighting to defend their country? Because that's what I said we should do. If we get invaded, we should fight to defend our country. Apparently the judge says, no, just let them take over or something. I'm not too sure what she's trying to imply.
He suggests there is a group of persons who are organized nationally and who have been preparing an 45 training to rise up and to take back the nation and publicly hang those who are against them.
I did suggest, it's pretty crazy, I did suggest we promote going free of anti-whiteism, sharing love and well-being for all people, no matter their background or their race, including white folk. Making the world a better place for everybody, put an end to racial discrimination. Yeah, I did say that. We've got to rise up. We've got to take our nation back from vile, bigots who want to racially discriminate and make that the norm, make that okay. We've got to rise up. We've got to go free of that with love, okay? Put an end to racial discrimination. Yeah, we do. I think most people agree with me. Yeah? Again, unless you're a vile bigot who wants to racially discriminate, you're an anti-white. And no, I never said we should publicly hang those who oppose us. In fact, the actual true thing I said in regards to that was already mentioned earlier. That criminals who are committing treason should be put on trial, prosecuted. And that I do personally think that we should bring back the death penalty for traitors. That's a political policy. In regards to criminal justice and judicial system. What, aren't we allowed to make political policies regarding judicial systems and what a crime is, what a punishment for a crime is? Oh, but they want to punish me for alleged crime. But if I want to get into politics and promote a policy which is in regards to the sentencing of convicted criminals, then, it's a problem. Why? Because I want to bring back the death penalty for people who actually need it, who deserve it. Again, the only people who have a problem with this are the folk who are committing the crimes, which would make them guilty and therefore justified to be put to death for the death sentence. If you're not going to do the crimes that would have you put to death for the death sentence, if you're not that crazy of a criminal, then why would you even worry? Don't you think it's good that those psychos would be actually put to death? Or at least like pedophiles castrated or something? Yeah. If we're not going to hang them, can we at least castrate them so they're not raping children? I don't know, we've got to do something about it.
He states in that video, those of us who have organized nationally and have been training and preparing are going to rise up, and we're going to take back the nation, and then we're going to put law back in order, and then everybody who wasn't with us and isn't with us now is going to be prosecuted and tried for 5 treason, okay? And he concludes with a rallying call as follows. He states, You need to take things seriously. You need to wake the fuck up, and you need to realize that we're at war. This is a battle for the existence of our people. This is a battle for the survival of your grandchildren and your children. The question is, does the content breach the standard of offensiveness required by Section 474.17 and as 10 discussed in...
No. Clearly, as we've gone through, we've all seen, I have to be innocent. It doesn't meet the requirement because I'm not targeting any person or group or anything like this. I'm saying that the targeting of groups has to end, and those vile bigots who are responsible for racial discrimination and treason need to be tried for their crimes and sentenced once they are prosecuted, once they go through the correct legal procedures. But, of course, now let us watch how this anti-white judge herself, who I think may be one of these individuals who might have to be put on trial for treason, right, for being anti-white. This is who I'm talking about. Like I've been saying from the beginning. Like people like this white judge is who I'm directly talking about, clearly. But let's watch how she will now lie, make nonsense up to stereotype me with racial discrimination, racial stereotypes, okay? She's going to racially discriminate against me soon, prove that she is an anti-white criminal, right? Prove me correct. And she's going to lie and try to say that I'm an evil, bad, white, scary white. And I'm not talking about anti-whites like her who are acting like criminals. No. I'm actually talking about hanging non-whites. Because I'm an evil R-word. Alright? So let's pay attention and watch how she tries to spin me saying criminals like her, alright, committing treason and corruption within our judicial system, within the political system, etc., ruining our country, elite bastards committing treason, robbing you for all your taxes and stuff. They're taking everything from you. They keep destroying the economy. All right, they're ruining everything. They're taking everything from every citizen. They're making us all poorer and poorer while they go off on their private jets. All right, these rich bastards. That's what I'm clearly talking about. And watch how one of them right now will spin and say, oh, I'm not actually just talking about how they're the problem. I'm an evil white man who wants to kill non-white people. Whoa. So, guilty. Shut up and stop trying to stop us criminals who are actual problem. Stop trying to be a hero like the Anzacs and defend your nation and stop the treason and the destruction of your nation, the abuse of your children. Shut your mouth. We're going to paint you as an evil white man. Now let's watch this happen.
That is, it is necessary that the use or content be calculated or likely to arouse significant anger, significant resentment, outrage, disgust or hatred in the mind of a reasonable person in all the circumstances. It's clear that the only reasonable inference to draw is that the defendant is referring 15 to a war against non-white people and persons who sympathize with non-white persons presently occurring in Australia, and that non-white people and sympathizers, by inference, are the enemies plotting to massacre and rape.
And would you look at that, folks? Would you look at that? The only made up thing we can just assume out of nowhere because we want to racially discriminate this innocent man because he's talking about how we're criminals and we're destroying the country. We're actually ruining the lives of the Aboriginal people, the white Australians, all the other non-white immigrants and stuff, destroying their lives too, stealing all of their money too. The Africans, the Jews, everybody. Chinese, the Greeks, the freaking everybody. Or the freaking Wogs, Muslims, they're robbing us all. So instead of being able to help all races of people, help all Australian citizens have a better life, have some more freedom, and protect all children of all races from sickos like pedophiles and whatnot, No, let's not do that. Let's not make the country a better place for everyone of all race, have love and well-being for all people, no matter their background, no matter their race, and actually make this country a fucking brilliant country again. No. Let's lie about heroes like the Anzacs, heroes standing up to actually make a difference and defend this nation. Let's lie about them, slander them, okay? Racially discriminate against them because they're white. Pretend like they're evil, scary white people who just want to hurt the innocent non-white people. Paint them as that stereotype so you can attack them, justify your attacks on them, and then shut them down, silence them, so nothing will ever get done. And all races of all people in this country, every Australian citizen, is just fucked around even more and more and more. Good on you, Judge. Good on you. You proved me 100% correct.
Being white people, but that war will break out leading to people being killed in the streets in a most violent manner. The language can properly be characterized as alarmist, 20 inflammatory, grossly racist, highly provocative and divisive. Reference to enemies and foreigners in the context of this video permits of an inference to be drawn by a reasonable person as to a reference to non-white persons in the community and their sympathizers. The defendant's reference to true blue Aussies on the other side of the war being a reference to white Australians. This content, 25, appears to be an encouragement to contemplate civil war and to use violence against non-white persons. I turn into the second video entitled Our Greatest Adversary. The defendant suggests and identifies his...
So you just heard the judge prove me 100% correct, lie and try to paint me with, racial discrimination. I'm the evil baddie who wants to hurt non-white people. And then, in the very next sentence, actually explain what I actually said. And let's hear what I actually say, exposing that what they just made up and then used as the thing to decide my guilt in the court case. That her very next sentence, she proves that she just made that shit up, just so she could say I was guilty. Have a listen.
The oligarchic parasitical class of politician and 30 their banker cohorts and their media outlets, the judicial system of courts and police officers that are bought out and paid for to serve anti-white ends and anti-Australian.
Wait, you just heard that right, folks? I'm going to replay that one, actually. We're going to listen to that over again. We might listen to it 2 times over again, just so we can be sure that I definitely just said, okay, we're gonna kill, quote unquote, allegedly, we're gonna kill non-whites, alright, because we're evil bad whiteys and we want to hurt non-white people. Yeah, that's what I've definitely just said. So I'm actually I am guilty. Yeah. I'm actually guilty, because that's what I just said. We'll listen to it again.
The oligarchic parasitical class of politician and 30 their banker cohorts and their media outlets, the judicial system of courts and police officers that are bought out and paid for to serve anti-white ends and anti-Australian.
Well, there you go, folks. You just heard it yourself. I clearly said there that we're going to kill non-white people. Yeah, that's definitely what I just said. We'll listen to it again, just to make sure the judge isn't lying and didn't just make that up to say I'm guilty when I'm actually innocent. And the entire court case, the entire transcript, all the evidence, even the evidence against me in this case, proved that I was innocent. No, and that's not the case at all. I definitely said right there, we're going to kill non-whites. So we'll listen to it again, just to make sure the judge definitely didn't lie.
The oligarchic parasitical class of politician and 30 their banker cohorts and their media outlets, the judicial system of courts and police officers that are bought out and paid for to serve anti-white ends and anti-Australian. The defendant uses highly provocative and emotive language to claim a birthright to possession of all of the nation's resources. He claims that is being stolen, stating, the entire nation, Everything in this nation, all of the resources in 35 our nation belongs to us white Australians. That is our birthright and it is being stolen.
So here I'm just saying that we're being dehumanized, we're being discriminated against as a race to the point where we're being treated as second-class citizens because of the colour of our skin. Right? And then the judge is like, no, you already are second class. You already are subhuman because you're white. It's not that you're becoming. You already are subhuman scum because of your race, the judge reckons. You don't deserve to have rights as a citizen because you're white. Whoa. Nice lady.
He suggests that everything we have was created by our ancestors and our parents, and those who have come before us.
So I must be wrong. Australia must have been built by Martians from the future? What? So there you have it, folks, straight from the horse's mouth. I say, whites deserve to be treated as equals. We shouldn't be treated as subhumans. We deserve rights as well. We shouldn't be discriminated on the basis of our race. And then the judge says, oh, really? So what you're saying is you want to take away the rights of non-white people. You want to, because you're evil white and you're subhuman. And you don't deserve rights because you're race, because you're white. And I'm an anti-white bigot. Oh. Yeah. She did just say that, didn't she, folks? Yeah.
With the 40 blood, sweat from the creation of everything in the nation and promotes an idea, 45 of a birthright of white people to the resources of the nation, which has no basis in reality and is not supported by...
Oh yeah, it must have been the Martians then, eh? So again, let's see what the judge pretends I'm saying when I'm talking about white, anti-white victimizers like herself. White folk like herself. This is what she says I'm talking about, actually.
To non-white Australians in Australia or non-white sympathisers. He, 15, suggests that if the whites surrendered to their conquest, then they will hunt us down until the very last white man is in their sights. He goes on, no longer can we surrender to this anti-white persecution. No longer can we bend the knee to those vultures and parasites who desire to see our proud stock mixed out of existence. No longer shall we bear the patience of mercy for those defilers and liars and cheats. 20 These traitors and their banking masters must be made to bend the knee to us. We are in charge now. I shall choose my own fate and I pray for those who would dare stand in my way, for the law is kill or be killed, and no longer shall we bow down to tyrants. 25 The defendant uses highly divisive and inflammatory language that incites violence based on perceived grace and perceived grace.
When did I ever do that?
Empathies. The language suggests that white Australians are potentially at risk of being hunted down and killed by non-white and non-white sympathisers.
Okay, so we're almost done, folks. And in this entire court case, this entire transcript, can you recall how many times I did what the judge is suggesting that I did, and I'm targeting non-whites with violence? Ding! That's right, 0. So far, 0 times. So, perhaps, maybe I'm actually just talking about anti-whites. How many times have I said that? Hundreds of times. So I've targeted non-whites from my mouth, the things that I said. Ding, 0. Not once. Not once yet have I said anything targeting non-whites. But I've said hundreds of things targeting anti-whites. Like this disgusting judge. This white, anti-white disgusting judge. Haven't I? Oh, yeah. That's right. It's almost like she's lying. You can keep repeating it, but it don't make it real or true. I didn't say it. The UN wrote it into international law. You read the document in the court case. proving they're just anti-white, it's the same as calling a black person the N-word. Except with white people, we get called the R-word. So, not a reasonable person is, again, somebody who would run around racially discriminating on the basis of someone's race, dehumanising and calling a black person or acting, oh no, you're subhuman, you're the N-word because the colour of your skin. Is that a reasonable person? No. So when they do it to somebody who's white and they call us the R-word, it's just as bad.
Libelous lead, monologue 20 minutes, an defendant in the use of more 10 inflammatory pro-white language in the audio videos with respect to the circumstance that a reasonable person in all of the circumstances would find the content offensive. Further evidence is in the form of prior encounters between the defendant and others that gave, to my mind, the defendant notice of the likelihood of causing offense to reasonable persons. For example, in the video entitled ISIS 15 War uploaded on the 6th of October, 2019, he referred to an encounter with a man who had ripped down the defendant's campaign posters. The defendant described him as a delusion.
This individual specifically, okay, just so everyone knows, actually was tearing down posters saying that white babies, white children deserve to be treated as humans. So, just so you know, there's a bit of context here. This individual that's being referred to, that the judge considers a reasonable person, thinks white babies should be abused because of their race. That's the type of people the judge is saying is reasonable.
Further, in the video entitled Our Greatest Adversary uploaded on the 8th of October 2019, that video clearly demonstrates the defendant's misguided view that he and his followers need not be concerned about causing offense, because his view, as he expresses in that video, is that he's entitled to be offensive if he's not expressing, if he's expressing a
which is what we all heard the High Court say before.
Political view. That suggests he's well aware of the offensive nature of the content he's posting. For example, he stated, when we, 25, express ourselves politically, no matter who it offends, no matter who wants to say it is hate speech, no matter who tries to censor us, we are protected under the Constitution, and anyone who tries to disagree with us. He refers later in the same speech to the possibility of himself being convicted for hate.
Oh yeah, so, because I was wise enough to be well aware that if I'm going to try to stand up against the racial persecution, discrimination of my people, then I'm going to be racially discriminated by those bigots who I'm standing up against. That must mean, because I knew that I was going to be persecuted by the very bigots who I'm trying to, oppose because I'm against their bigotry, that means I magically knew that I was actually secretly offensive. Dun dun dun.
If the courts convict me of hate speech, he goes on, it's clear that he's cognizant of the 30 offensiveness, the risk of causing offense, or that the reasonable person would find the material to be offensive in those circumstances. A further example in that same video, Our Greatest Adversary, is when he stated, the defendant stated, we can say what we like when we like as long as it is, again, 35 political expression. Like I explained, we can't. We don't have the First Amendment. We can't just go out in the street and say anything we want for any reason. But if it is political expression, which any discussion opposing immigration, Islam, Judaism, etc., any foreign entity or foreign religion, right, this is a political expression and we are protected. In so doing, the defendant indicates a keen awareness, in my 40 mind, that what he says may offend others, provoke others who disagree with his view to seek to censor him, to regard what he says as hate speech. He displays a keen awareness of the substantial risk that the reasonable person in all the circumstances will find the content offensive. 45. This is particularly so given the defendant's reference to the possibility of his own prosecution for hate speech offenses. A further example is contained in the Facebook screen captures, Exhibit 2, dated uploaded the 10th of October, 20 straight, that relates to a message 2 days after the defendant posted the video, Our Greatest Adversary, on the 8th of October, 2019. Full stop. The evidence includes the reactions of a member of the public to the defendant's views, including Kay Ritson on the 10th of October, 2019, who responded to a post by the defendant with the words, "Purveyor, 5 of racism and bigotry," to which the defendant responded arguing the point. A further example is contained in Exhibit 3, which is a letter seized as part of the search warrant dated. That letter's dated the 13th of October, 2019, and it refers in its content to an encounter with a member of the public on the 13th of October, 2019, at approximately 1:30 in the afternoon when the defendant is said to have been out, 10 campaigning, putting up some posters when a young couple began stalking me, he wrote, and destroying my campaign.
And remember, he pushed me into oncoming traffic and I almost got hit by a car and died? Yeah, conveniently leave that part out again.
It's of note that the video Nowhere to Run was created, according to Exhibit 4. Record 1172 of page 194, at 2056 that evening, after the...
Oh, that's right. So I made the video where I was warning people, talking about how psychopathic anti-whites will literally hunt us down to kill us because we're white. An hour or so after, a psychopathic anti-white actually tried to assassinate me in broad daylight, in public, in Bouval.
It seems, referred 15 to in the letter located in the search, given my findings as to credit and the matters referred to, I find that the only reasonable inference to draw from the evidence is that the defendant was, in fact, aware of the substantial risks that a reasonable person would find the content of the 3 recordings, of the 4 recordings to be offensive. I'm satisfied that the defendant was so aware, and I'm satisfied of that too. 20. The standard of beyond reasonable doubt. I must further be satisfied that having regard to the circumstances known to the accused, it was unjustifiable for the defendant to take that risk. I must be satisfied that the defendant, being aware of that risk, that is that it was unjustifiable, 25 him to take that risk, given the grossly divisive and grossly offensive nature of the content of the material posted for the world at large to access via social media, the potentially very large audience that would be exposed to that content, and in their living rooms and private domains wherever they access their personal computer devices, and the considerable emotive reaction likely to be provoked by the material. 30. Particularly having regard to the possible consequences, I find that it was unjustifiable for the defendant to have taken that risk. Accordingly, I find on the basis of the evidence as discussed, being satisfied beyond reasonable doubt, that the defendant was reckless with respect to the relevant 35 circumstance that reasonable persons would regard the use of the carriage service as being offensive. In conclusion, I find that the prosecution have proved each element of the charge of using a carriage service to menace, harass or cause offence pursuant to section 474.17 of the Commonwealth Criminal Code beyond reasonable doubt. Accordingly, I find you, Mr. Foster, guilty of that charge and I convict you of that. 40.
So, there you have it, folks. As we all saw, the corruption has been exposed. Please download this video, watch it with your family, share it with your friends, save it on a CD or something, put it on a USB, I don't know, drop it in someone's mailbox. I'm clearly innocent. It's been proven to the world now. It's all been exposed. I'm definitely 100% innocent. Every single reason that was used to, convict me and say, oh, yep, definitely guilty, was made up lies from the judge. And all the actual evidence of the court case proved my innocence. So the reason why you can't vote for me right now, folks, the reason why I won't be in the Queensland Senate making this country better for everybody in this upcoming election is because I currently can't run as I'm under sentence. So I don't know about you guys, but I have this strange feeling that all of this might just be illegal political interference. But I'll let you decide on that for yourself. I don't know, that's just the feeling I get. If you want to help start a GoFundMe, I want to get a decent lawyer who has good ethics and cares about this nation and our democracy and wants to put an end to corruption. And we're going to appeal this case, even if we have to appeal it all the way to the High Court of Australia, to set a legal precedent, to put an end to racial discrimination and protect all citizens of Australia, no matter their race or background or immutable characteristics, even if they are white. Because we are all human, we all deserve respect and well-being, even members of Western kind. And I hope all good people out there can agree and see we need to start working together as Australian citizens to actually make this country great again, fix all the corruption, all the nonsense, bring down the prices of everything, raise the wages, get rid of inflation, all right? Get back to a gold standard, actually have abundance, jobs for everyone, end homelessness, end poverty, all right? We can do all of this. We can do it in a decade's time if we work together and get these corrupt bastards who are currently running our country out of the picture, so we, true blue Australians, all of us, of all races, can work together, stop the anti-white, stop all bigots, and actually protect our children. Again, no matter the race, all children deserve to have a future. So let's do it for them. Make this go viral, folks. We are going to rise up with love, prove these anti-white bastards wrong, and show the world that we are the heroes they fear us to be. We're going to get in the Senate. We're going to get the major parties out. We can do it. Thank you. Raymond Foster.